In the world of business, supply agreements are like the glue holding your operations together. But when they go wrong, they can cost you time, money, and a whole lot of frustration. Let's talk about the real-world examples of supplier disputes, why they happen, and most importantly, how you can avoid being caught in the same mess. Picture this. A growing Florida construction company signs a contract with a supplier to deliver materials for a major project. Everything looks good on paper, but halfway through the job, the supplier starts missing deadlines. The company has workers on site, a schedule to maintain, and no materials to work with. Delays pile up, penalties kick in, and the business begins bleeding money. So what went wrong? Most often, disputes like these boil down to vague supplier agreements. Maybe the delivery timelines weren't clearly defined. Maybe the penalties for non-performance weren't spelled out. Or perhaps the contract didn't specify what happens if raw materials prices suddenly spike, which is a common scenario these days. Without clear terms, disagreements can spiral out of control, and both parties end up pointing fingers. Another issue we see often is a lack of legal oversight. Businesses eager to move fast sometimes use boilerplate contracts they find online or pull from an old deal. The problem is that every supplier relationship is unique. If your agreement doesn't reflect the specifics of your deal, like payment terms, performance expectations, or remedies for a breach, you're exposing yourself to unnecessary risk. And here's another thing. A dispute doesn't just cost you money. It can damage your business relationships, hurt your reputation, and delay growth opportunities. In one Florida case, a retailer lost a key supplier after a messy contract dispute, leaving them scrambling for alternatives. The lesson here? A solid supplier agreement can save you from all these headaches. Work with a business attorney who knows what to look for, someone who can draft clear, enforceable terms and anticipate potential risks. Spell out delivery schedules, quality standards, penalties for delays, and dispute resolution processes. It's all about setting expectations up front so there's no confusion down the line. At the end of the day, the cost of a well-drafted contract is nothing compared to the financial and reputational damage of a supplier dispute gone wrong. So take the time, get it right, and protect your business.